Emma, shall we start now?
Yes, please.
Okay. Thank you. Good morning, good afternoon, good evening. Thank you for joining us. We welcome you from wherever you're joining us across the world. My name is Ined Muthoni. I work for the Center for Reproductive Rights. I'm delighted to facilitate the panel today, the discussion today. And we are really thrilled to be here today with you to launch the Center's new report, which we are calling Across the Borders: How International and Regional Reproductive Rights Cases Influence Jurisprudence Worldwide. For the very first time, this report maps how the precedents set by several key international and regional reproductive rights cases that the Center has litigated have reverberated across the borders and influenced the development of jurisprudence worldwide. And we are going to, before we get into the report, we'll be having some administrative announcements, and then we'll have a short presentation of the report itself, followed by an exciting panel where human rights experts and members of civil society will discuss the importance of international and regional norms in establishing co-protection at the national level for sexual and reproductive health and rights, and also for human rights in general. And so quickly, before we start off, please note that we are recording this event to make it accessible to those who are not able to join us today. And we are going to be having this the recording shared on our website, for CRR website. We are also providing Spanish interpretation for the session. If you look at the bottom right-hand corner of your screen, you'll see a globe icon that if you click on that, you can be able to access the Spanish interpretation. We will also save time at the end for the audience to have some question and answer session. And so please use, again, if you look at the bottom of your screen, you will see an icon written Q&A. Use that to submit your questions that you have to the panelists. We will moderate those questions after the presentation. Now, before we jump into the report itself, I would like to start by just saying a few things about the reality of sexual and reproductive health and rights globally. As we know, reproductive rights are really essential to the realization of human rights and are critical to good health, survival, dignity, poverty reduction, equality, and the enjoyment of a wide range of human rights. They encompass a spectrum of civil, political, economic, and social rights, starting from the right to health and life, to the right to equality and non-discrimination, privacy, information, and the right to be free from ill treatment, all these which are enshrined in major regional and international human rights treaties. These are increasingly also recognized autonomously at the constitutional level in jurisdictions across the world, as well as by national courts and tribunals and regional and international human rights bodies and courts. It is noteworthy that a lot of progress has been made over the past 25 years, with an overwhelming trend towards, for example, liberalization of abortion laws and the recognition of maternal health as a human right in many jurisdictions and human rights systems. And this translates into public health interventions that have actually lowered maternal deaths worldwide. For example, from 2000 to 2017, the global maternal mortality rate declined by 38%, with South Asia achieving the greatest overall percentage reduction in maternal mortality rates, with a reduction of 59%, followed by Sub-Saharan Africa with a reduction of 39% during the period. Since 1994, nearly 60 countries have adopted laws that have expanded the grounds upon which abortion is permitted. and only 3 countries have imposed greater restrictions. This trend towards liberalization is particularly visible in the number of countries that have removed complete bans. In 1994, 40 countries prohibited abortion altogether, and today only 24 countries have complete bans. While most countries introduced exceptions gradually, Nepal and Sao Tome and Principe transitioned immediately from absolute bans on abortion to allowing abortion on request. And these few, of course, there are few examples where we know that abortion is getting more restricted, and this has been mostly in places where democratic institutions have been eroded, such as in Poland and in Nicaragua. We've also seen liberalization of laws that has grown recently, with 3 countries reforming their laws in 2020, and compared to 6 countries that removed restrictions in 2021. And these are notably Argentina, Ecuador, India, Mexico, South Korea, and Thailand, which have all expanded grounds for abortion. And we are also very excited to note an increasing and progressive movement towards decriminalizing abortion. We've seen, for example, Australia and South Korea join Canada, where they fully decriminalized abortion, and they've instead regulate abortion through health regulations like any other medical service. Of course, we know that also countries have taken different paths to liberalizing abortion. Some have done it through referendum, as for example, you'll know through Ireland. Others have done it through legislative processes or through constitutional and Supreme Court decisions. Recently, the highest court in Mexico and Ecuador liberalized restrictive abortion legislation by relying on international human rights law, among other sources. As of January 2022, 74 countries permit abortion on request, although with varying gestational limits. I would also, of course, be remiss if I don't mention that the COVID-19 pandemic did hinder access to sexual reproductive health and rights all over the world generally, but it has also sparked some progress. For example, in 2020, the United Kingdom temporarily approved the use of medication abortion via telemedicine for pregnancies up to 9 weeks and 6 days to ensure that access to abortion is available during the pandemic. Some of these gains, we hope, can still be maintained as we build back stronger and better. However, despite this progress, we still have a long way to go for states to fulfill their human rights obligations in the area of reproductive health and rights. For example, we know still over 800 women are dying each day from complications in pregnancy and childbirth. And for every woman who dies, approximately 20 others suffer serious injuries, infections, and disabilities. Unsafe abortion is still a neglected public health problem, contributing to 13% of maternal deaths worldwide. In some parts of the world, like Africa, the vast majority of the abortions are undertaken in unsafe, resulting in 1 maternal death per 150 cases. The prevalence of unsafe abortion is, of course, associated with restrictive abortion laws, poor quality of health services, and low community awareness, which leads to stigma. Maternal mortality itself is associated as well with legal frameworks that do not impose positive obligations on states to guarantee access to care without discrimination, including on ethnic, racial, and socioeconomic grounds. Therefore, an initial and essential step to respect and guarantee reproductive rights is its recognition and protection. And this publication that we are sharing today and the discussion with the panels will illustrate what gains have been made moving towards this direction. To start us off in this very important conversation, I would like to introduce my colleague, Alejandra Cardenas, who is going to introduce us to the report. Ale is the Senior Director of our Global Legal Strategies Unit, which is the unit tasked with ensuring technical excellence, strategic and intellectual alignment, as well as spearheading our thought leadership work at the center. Alejandra also provides oversight and support for our global litigation, and this publication was created by the unit that she leads. So Ali, welcome. Take us through the report.
Thank you, Enid, and good morning, good afternoon, and good evening, everybody. We're really excited to have the opportunity to share this report with you today. Strategic litigation is an essential tool that has been used by SRHR advocates to advance universal access to sexual and reproductive health services to make progress towards gender equality. And over the past 2 decades, the Center for Reproductive Rights, in partnership with local and national level organizations, has brought groundbreaking litigation before international and regional human rights bodies to secure, protect, and advance rights across a range of sexual and reproductive health issues, including abortion, maternal health, and adolescents' rights. The report we're launching today tracks the legal influence of 6 of these landmark cases over time, demonstrating the transformative potential of successful litigation before international and regional bodies, not only in the countries where the decisions were rendered, but across borders and regions. A report across borders, how international and regional reproductive rights cases influence jurisprudence worldwide, documents how these cases have become foundational aspects of legal protections for women and girls, reproductive autonomy and decision-making for courts from across the globe that have relied on these landmark cases to build and strengthen legal standards of their own. I wanted to share 2 concrete examples of the cascading effects that some of these cases have had. I'll start with a case we litigated against Peru. It's the case of KL v. Peru. In 2005, the Human Rights Committee issued a groundbreaking decision in KL v. Peru, recognizing that the denial of abortion services constitutes a human rights violation, including the right to be free from cruel, inhumane, and degrading treatment, the right to privacy, and the right to special measures of protections for minors. In addition, the committee established that where abortion is legal, it must be accessible, including for minors. The facts of the case, I'll explain briefly. When KL was 17, she learned she was carrying a pregnancy with a fatal fetal impairment, meaning that there was no chance of survival after birth. Although KL was legally entitled to an abortion in Peru, as the pregnancy posed a risk to her life, her physical and mental well-being, she was denied access to abortion services. KL was ultimately forced to carry the pregnancy to term, and the baby died several days after birth. Now, let me take you to the ramifications, the unplanned impact this decision has had. Well, this decision has been key in 1, it influenced the Inter-American Court of Human Rights to establish that protections of life prior to birth are not absolute and instead must be gradual and incremental. In this regard, the court references the Human Rights Committee's determination in the KL case that compelling a woman to carry to term a pregnancy that puts her life, physical, mental, and mental health in grave danger violates the right to be free from cruel, inhumane, and degrading treatment. Another example has been how domestic courts in Latin America have repeatedly cited and rely on KL v. Peru in decisions on safe and legal abortion, including in a series of landmark constitutional jurisprudence expanding the grounds under which abortion is legal in Argentina, Colombia, and Brazil. In 2006, the Colombian Constitutional Court overturned the country's absolute ban on abortion, recognizing that access to abortion as a human rights under some grounds. The court relied on KL in recognizing that denial of abortion services in certain circumstances can amount to cruel, inhumane, and degrading treatment. Let's fast forward to 2012, when a decision recognizing that all women who became pregnant as a result of rape could legally access abortion care was rendered by Argentina's Supreme Court. Argentina's Supreme Court looked to the decision on KL as reinforcing states' obligations to remove all obstacles to legal abortion services. In this regard, the court explicitly referenced the Human Rights Committee's decision in KL and the findings that denial of abortion care, again, can amount to cruel, inhumane, and degrading treatment. Further, the court relied on KL to reinforce that denying abortion to a minor violates the prohibition against ill treatment and that there is a special duty of care for minors. That same year, Brazil's Supreme Court issued a decision authorizing abortion in cases of anencephaly, which explicitly referenced the Human Rights Committee's decision in KL v. Peru. KL was also influential in two lower court decisions on abortion in Argentina and Colombia. In a case decided in 2015 in Argentina, a woman who became pregnant from rape terminated her pregnancy, and both her and the medical provider she relied on were reported to the police. The court concluded that neither the women nor the provider were liable for a criminal offense, relying on Human Rights Committee's recognition of states' obligation to ensure safe access to legal abortion and remove institutional and judicial barriers impeding access to legal abortion services. In the Colombian case T388 from 2009, a woman whose fetus had fetal impairments was referred to abortion care, but a judge rejected her petition for an abortion. This decision was appealed, and the second judge granted her permission to get the abortion. In its decision, this judge relied on KL's recognition that denying an abortion in instances of fetal impairments incompatible with life amount to cruel, inhumane, and degrading treatment. KL has also been reinforced in decisions made by the Human Rights Committee itself in cases against Ireland and Argentina. The other example I wanted to share was that of the case of Aline v. Brazil. The first ever international human rights decision to hold government accountable for a preventable maternal death, and recognizing how discrimination was a deciding factor in the death of Aline. The CRR Committee affirmed states' obligation to ensure that provision of timely, adequate maternal health care to all women, regardless of race or income, and that it is insufficient for states to take measures to improve maternal health, which neglect marginalized sectors of the population. Further, the CRR Committee recognized that when a state outsources the provision of medical services to private institutions, as occurred in this case, the state is directly responsible for private institutions' actions and must regulate and monitor these institutions. Aline was a woman of Afro-Brazilian descent who went to a private health clinic seeking care for complications with her pregnancy. The hospital initially sent her home, and when she returned, because she just became increasingly ill, the doctors were unable to detect a fetal heartbeat. Her labor was induced, and she gave birth to a stillborn fetus. However, the medical staff failed to extract her placenta until 14 hours after the birth. And when she was finally transported to an intensive care facility, she was left untreated in a hallway where she died. The CRR Committee determined that Brazil had violated the right to access justice, its obligation of due diligence to regulate activities of private actors, and the right to health in conjunction with the right to be free from discrimination. The CRR Committee found that the lack of appropriate maternal health services failed to meet the specific distinct health needs and interests of women. It further recognized that Aline was discriminated against on multiple grounds, including on the basis of her sex, her status as a woman of African descent, and her socioeconomic background. The Aline case would then become instrumental in decisions recognizing the right to maternal health in Kenya, Uganda, the Netherlands, and Portugal. In 2015, the High Court of Kenya decided a case, is the case of Millicent Awor Maimuna and Margaret Anyoso Liele, the Attorney General and others, of women that were detained by a hospital at various times due to their inability to pay their medical bills relating to abortion and delivery. While being detained at the hospital, the women were subjected to degrading conditions, including having to sleep on a floor next to a floating toilet and being denied adequate food and postnatal care. The High Court of Kenya noted the similarities between the petitioners and Aline's case, as they all come from disadvantaged backgrounds. The court also relied upon the judgment of Aline in finding that inadequate maternal health services that fail to meet the health needs of women are a form of discrimination. The court further cited Aline when referring to a lack of maternal health care having a differential impact on a woman's right to life, and in recognizing that policies created to eliminate discrimination against women need to have clear actions and be adequately funded. In 2020, the Constitutional Court of Uganda, in the case of Center for Health, Human Rights and Development, the Attorney General, looked to Aline in recognizing that the rights to life and health are interconnected and that lack of appropriate maternal health care affects the right to life. This decision ultimately held the Ugandan government accountable for failing to provide adequate maternal health services, including emergency obstetric care, recognizing these as violations of the right to life and health, among other rights. Then let's move to the Netherlands. In Garrett v. Netherlands, a case concerning a minimum income requirement that prevented a poor single mother from moving to the residence of her choosing, two European Court of Human Rights judges rely on Aline in their dissent to emphasize the importance of viewing this case through a lens of intersectional discrimination. And finally, in Lopez de Sousa Fernandez v. Portugal, a European Court of Human Rights case concerning state accountability for a death occurring from medical negligence, one of the judges invoked Aline in a partial dissent, urging the court to recognize the universal standard of states' responsibility for contracts out to private facilities. Through examples highlighted in my presentation, I hope I have shed some light into the impact of human rights jurisprudence and cases decided by regional and global bodies and courts, extending across jurisdictions and showing the reliance and interdependence of this corpus juris fabricated in a flow that moves downwards from the global to the regional to national jurisdictions, as well as upwards and horizontally, constantly expanding the scope of human rights and the obligations that states have to meet their human rights obligations, in particular in the area of health and rights, of sexual and reproductive health and rights. Thank you, everybody.
Thank you, Ale, for that very elaborate presentation of the report. And now we are going to get into the expert discussion. I'm going to introduce all the panelists first, and then I will direct specific questions to each of them. And so starting off with the introductions, I am delighted to introduce Ms. Vandana Rana from Nepal, who is a member of the UN CEDAW Committee and currently the chair of the Working Group on Inquiries. Ms. Rana is also a member of the UNFPA High-Level Commission on ICPD plus 25 follow-up. She has 3 decades of experience in promoting women's rights and gender equality at the grassroots, national, regional, and the global level. And she is one of the founders and strategic advisor of SATHI, a pioneer NGO working on violence against women and girls in Nepal. She is the chair of the board of directors of the Global Network of Women Peace Builders and a former member of the UN Women Global Civil Society Advisory Group and chair of the Global Network of Women's Shelters and former chair of the National Women's Commission of Nepal. Welcome, Ms. Vandana. It's really good to see you again. I will next introduce Ms. Susana Chavez, who is an obstetrician and professor of public health with training in public policy. She is the founder and the executive director of PromSex, Center for the Promotion and Defense of Sexual and Reproductive Rights, a Peruvian feminist NGO that works on advancing sexual and reproductive autonomy, dignity, justice, and equality. She is also the executive secretary of the consortium promoting safe abortion in Latin America. Together with the center, PromSex litigated the groundbreaking case of LC versus Peru before the CEDAW committee. Welcome, Susana. I will next introduce Mr. Moses Mulumba, who is the Director General of Afya Haki, AHAKI, which is a leading African institute that generates knowledge and builds capacities, advocacy capacities in health, human rights, and sexual reproductive health and rights using Afrocentric approaches within a national and global context. He is a lawyer with a special interest in international human rights, global health, and sexual reproductive health and rights. He is a steering committee member of the Regional Network on Equity in Health in East and Southern Africa, Equinet. He was the founding executive director of the Center for Health, Human Rights and Democracy and Development, and has been an advisor to the HIV and Law Commission and former board member of the Uganda National Drug Authority. Welcome, Moses. Finally, I'm going to introduce Ms. Ona Flores. Ms. Flores is the Civic Freedom Research Advisor at the International Center for Nonprofit Law, ICNL. She leads ICNL support for the UN Special Rapporteur on the rights to freedom of peaceful assembly and association. She is an international human rights lawyer with more than 15 years of experience working in the inter-American human rights system and engaging with the UN human rights mechanisms. She also worked as a senior staff attorney at the Office of the Special Rapporteur for Freedom of Expression of the Inter-American Commission on Human Rights, a program coordinator at the Human Rights Center of the University of Chile, and also as an attorney in the Inter-American Court on Human Rights. Welcome our distinguished panelists. I'm now going to pose a question to each of you. You take a couple of minutes responding to the question, and then after we go through the panel, as Emma mentioned, they will go back. We'll then take questions from the floor. Ms. Rana, I have the pleasure of addressing the first question to you. As a member of the CEDAW committee, can you share with us your perspective on the importance of United Nations human rights bodies in establishing global norms on sexual and reproductive health and rights, and the role of strategic litigation? You could also highlight to us what challenges or factors are threatening this globalized setup that attributed importance to supranational human rights bodies. Welcome.
Thank you. Thank you so much. It's an honor to be sharing a panel with such profound dignitaries working in this sector. And first of all, I would like to congratulate the Center for Reproductive Rights on the launch of its new report, Across Borders, How International and Regional Reproductive Rights Cases Influence Jurisprudence Worldwide. I went through the report and I found it very, very informative and very useful for someone like me who's in the CEDAW committee itself to refer to it as well. Unfortunately, I wasn't there in 2011 when the landmark human rights decision was taken by CEDAW, and thank you, Susanna, for that, for that persistent work. The cases presented in the report clearly validate how international and regional human rights bodies have helped in establishing norms on sexual and reproductive health and rights, and the use of numerous litigation to accelerate the protection of sexual and reproductive health and rights across the globe through its various functions, such as country assessments, concluding observations, general recommendations, standard setting, global reviews, monitoring, and evaluation. As presented in the report, these cases have ensured access to justice for individuals harmed by reproductive rights violations and, in many contexts, resulted in concrete legal and policy reforms. I completely agree with what has been stated in the report that the normative standards have proven instrumental in not only holding states to account for human rights violations, but also in the development of landmark domestic jurisprudence recognizing the centrality of reproductive rights as human rights, such as how the norms established by these cases have permeated legal discourses, influenced human rights bodies, general comments, and concluding observations. As you also mentioned in the report, Nepal has also benefited from this jurisprudence where we have liberalized the laws on abortion, you know. So it has, I mean, just giving an example of Nepal where there are many instances where we have used these jurisprudence. Covering the expanse of sexual and reproductive health rights are being done by UN human rights mechanisms and strategic litigation from the angles including the right to life, the right to be free from torture, the right to health, the right to privacy, the right to education, and the prohibition of discrimination. Areas where critical norms have been established are recognition, protection, and rehabilitative measures to violations of women's sexual and reproductive health in all forms, including denial of access to services that only women require, poor quality services, subjecting women's access to services to third-party authorization, forced sterilization, forced virginity examinations, and forced abortion without women's prior consent, and also FGM and early marriage. CEDAW has clearly indicated that women's right to health includes their sexual and reproductive health. This means that states have obligations to respect, protect, and fulfill rights related to women's sexual and reproductive health. CEDAW Article 16 guarantees women equal rights in deciding freely and responsibly on the number and spacing of their children, and to have access to the information, education, and means to enable them to exercise these rights. And Article 10 also specifies that women's right to education includes access to specific educational information to ensure the health and well-being of families, including information and advice on family planning. The CEDAW Committee's General Recommendation 24 recommends that states prioritize the prevention of unwanted pregnancy through family planning and sex education. These provisions have helped to influence strategic sexual and reproductive health rights litigation, which has great potentials to enhance victims' access to justice, contribute to legislative or societal transformation, inform legislation building, review or amend legislations, regulations, or policies, develop jurisprudence, raise awareness at the national or international level of particular issues, combat stigma, or addressing the consequences of sexual violence on victims. CEDAW, as well as other United Nations human rights bodies, as combined force, undertake consistent efforts for deeper work into exploring the identification of root causes in relation to violations of women's sexual and reproductive health and rights, and for development of pathways to address the deeply ingrained beliefs and societal values pertaining to women's sexuality. And these include urging state parties to eliminate the elimination of discriminatory stereotypes and all harmful practices, conducting public campaigns for women and men at all levels of society, awareness raising, sensitizing traditional and religious leaders, parents, teachers, advocating for educational policies, practices, textbooks, study materials, and providing training to the judiciary, law enforcement officials, journalists on gender equality. So I don't know if you want me to address the challenges right away now, or do we go on a second round? I just wanted to know that as well.
You can actually just speak to them right now. It's not a problem.
All right. Okay.
Yeah.
So this is how I mean, the report is extremely useful, as I said, very informative, where you have compiled those 6 cases, and it's going to be useful for the committee itself also. So these are how CEDAW and other UN bodies provide importance to this sector, and how the human rights decisions that they have made influence legislations throughout. In terms of, challenges that you asked me, challenges or factors that are threatening this globalized setup, I think in the recent years, these marginalized sections have been increasingly coming to attack across the world, including human rights defenders, the shrinking space of civil society, and the safety and security of human rights defenders, the risks they face specifically if you are working on sexual and reproductive health and rights in many countries. In terms of treaty body reporting, only 25 to 30 states have been able to report on time. 85% of states parties are unable to comply with their reporting obligations. Several of the treaty bodies with a reporting procedure have a structural backlog of reports. And now with the COVID, we still have more increasing backlogs. And with the inquiry procedure, the individual communications procedure, the backlogs is so immense and the work is so intense, it's increasing exponentially. And the human resources, the austerity measures that are consistently being applied does not have adequate human and financial resources to have these works. The jurisprudence that you are talking about, it's very slow because we don't have adequate human and financial resources and setup to take it up speedily as much as it comes. I think that's another one. And the other is, we have a coherence challenge also with 10 treaty bodies working on overlapping and interlinked human rights issues. Challenges regarding the coherence of the treaty body system are an ongoing concern. I also wanted to mention here, since I'm a member of the High-Level Commission of the Nairobi follow-up, which particularly focuses on sexual reproductive health and rights, which the High-Level Commission has come up with a report, No Exceptions, No Exclusions, Realizing the Sexual and Reproductive Health and Rights and Justice for All in November 2021. And the report is bold and forward-looking and contains important key messages and recommendations on the need to safeguard and accelerate implementation on sexual and reproductive health rights, which has been hampered due to the global COVID-19 pandemic. So it also provides some solutions which the human rights framework could also use in accelerating and expediting its international human rights obligations. So I'll stop here. Thank you.
Thank you so much, Ms. Rana. And sorry again for the interruption, but we got the points clearly on, of course, the importance role that the treaty, the human rights treaty bodies play, and of course the challenges that we are grappling with. I'll now move on to a second panelist, Ona Flores. Ms. Flores, welcome. My question to you is, the cases that we've mapped out in this report have been widely influential across Latin America and before the Inter-American human rights system. How has impact litigation transformed the landscape around sexual and reproductive health and rights in the region? And then secondly, if you could just briefly tell us what role has the constitutionalization of human rights across the region had on the relevance of international case law? So welcome, Ms. Flores, 5 minutes, thank you.
Thank you, Enid. It is also a pleasure to be here. Well, I just want to begin saying, as you clearly said in your presentation, that it has been and continues to be an uphill battle to ensure sexual and reproductive health and rights in Latin America, including access to legal and safe abortion. There's no denying that, and the struggle continues. However, I was clearly presented in the report over the course of the past 20 years, impact litigation on sexual and reproductive rights has achieved real changes in law and policies in our region, Latin America. For example, during these years and after a series of successful rulings, some countries in our region have gradually moved away from total prohibition of abortion to a state of decriminalization and legalization, as in the case of Mexico and Argentina that you mentioned and Alejandra mentioned. And other countries have opened up important spaces to continue expanding the protection of these rights, Ecuador being the latest example. Some of these changes were really simply unthinkable in a region still influenced by the Catholic Church and many of the Christian religions, fundamentalism that seek to exert total control over women's bodies and sexuality. But it's not just about the victory itself. there are many ways in which impact litigation has transformed the landscape of sexual reproductive rights in Latin America. It has empowered civil society and mobilized communities. It has gathered media attention and brought a focus on a conversation that is more public. You know, it has created international pressure for some governments. But I believe that the most transformative result of this litigation is at the level of the narratives or the legal discourse. Strategic litigation has fundamentally changed the narratives around sexual and reproductive health and granted legitimacy to the claims of women and other marginalized groups that have long been ignored. Impact litigation in Latin America has successfully articulated how sexual and reproductive health is rooted in human rights principles and norms. It has effectively claimed the human rights framework and its discourse and given meaning through the lived experience of many women. For people in our countries, if you think about it, of the last 20 years, for our people, for our courts, for our legal scholars, issues such abortion and in vitro fertilization went from an ethical and moral problem, mainly concerning our criminal laws and perhaps our medical practice, to a human rights issue engaging states' obligation. And this is not something to be taken for granted. I know I don't have much time, but I just want to, the jurisprudence of the Inter-American human rights system is perhaps the best example of how this happened. So you have, and you mentioned, Alejandra, and you, Enid, I don't know, for example, a strategic litigation by civil society that triggered important friendly sentiments and precautionary measures by the Inter-American Commission of Human Rights, Paulina Martinez with Mexico being one example. And these decisions recognize that sexual and reproductive health is really interdependent of the right to equality and non-discrimination, the right to physical and psychological integrity, the right to be free from sexual violence, and the right to access to justice. So they put at the center of the discussion the pain, the suffering, and the cruelty of policies that deny women and girls access to reproductive health. And these rulings, in a way, narrow the range of justifications that were commonly used by those promoting the oppression of women's bodies, you know, and our health. And then, but the discourse move on from the issues of cruelty and pain to those of autonomy. And then you have a new set of cases by the Inter-American Court on in vitro fertilization, forced sterilization, and criminalization of obstetric emergencies, in which the court expanded its analysis and recognized the human rights framework recognized and protected women's autonomy when it comes to sexual and reproductive matters. An autonomy that is embedded in the right to privacy, dignity, and access to information and health. This, obviously, as very well documented in the report, has cascading effect all over Latin America. I will not be a better job than the report explaining that, but I think the latest ruling of the Supreme Court of Mexico is a fantastic example. This ruling that ruled that the criminalization of abortion was unconstitutional, cites extensively the Inter-American Court decision of Octavia Murillo, which helps the Mexican justices to expand their understanding of the right to privacy so that it protects women's autonomy and the right to choose. Very broadly and really unthinkable 12 years before. And to finally answer your question, this has been possible in part because of another years-long movement in Latin America that has pushed the domestic constitutional courts to use and engage with decisions from the human rights bodies. Mexican constitutional legal doctrine, for example, has recognized that human rights treaties and the interpretation provided by treaty bodies are enforceable by domestic courts and binding on. Other countries such as Colombia, Argentina, and Ecuador have adopted a similar understanding where human rights treaties and decisions of treaty bodies are part of the constitutional bloc. This obviously has greatly been in great benefit for those litigating these cases and show the importance of efforts to protect international and human rights bodies against attacks that seek to weaken them. Thank you.
Thank you so much, Ona. And I know we are rushing a bit because of time, but I think you really elaborated how useful and how, of course, impactful this engagement has been in the region. And I think Latin America remains like a beacon of hope, even as a lot of things are going wrong across the world. So thank you so much for that elaboration. And of course, we'll still hear a little more from the region by speaking to Susanna. Susanna, the two of the cases that we mapped up in this report, KL versus Peru and LC versus Peru, focused on creating accountability for lack of access to legal abortion in Peru, but it had a rippling of effect both across the region and worldwide. Can you tell us about your experience incorporating human rights norms and mechanisms into domestic advocacy on abortion? And how has strategic litigation reinforced other efforts, advocacy efforts that you've used? So welcome, Susanna.
Muchísimas gracias, Enid. Muchísimas gracias al Centro de Derechos Reproductivos por esta oportunidad y por encontrarnos una vez más. Pero muy feliz, además, de ver cómo estos casos que vivimos en nuestros países tienen altísima repercusión y esta interdependencia que ustedes tan bien han señalado. Creo que el caso LC y KL coloca, por un lado, a derechos que han sido largamente ignorados. Fíjese que en el Perú el derecho al acceso al aborto por razones de salud está vigente desde 1924 y se tardaron muchísimos años y cientos de vidas de las mujeres, como tú bien lo señalabas, Enid, cuando hablabas de la muerte materna, miles de mujeres que han muerto a lo largo de estos años por no tener acceso a algo que la ley ya les reconocía. Y eso creo que es un tema sumamente importante porque sí estamos hablando de casos que sistemáticamente son negados, a pesar que nuestras leyes nacionales y nuestro marco internacional sí nos los permiten. El caso del aborto terapéutico colocó, y estas sentencias nos colocó en esta obligación imperativa, tuvo que enrostrar al Estado. Y eso creo que fue un cambio trascendental en la vida de las mujeres. Por un lado, que no es tan solo que hay víctimas que han asumido, sino cómo se previene la siguiente generación de víctimas. Y creo que ese impacto no se ha medido todavía en real dimensión, cuánto esto ha disminuido, inclusive como sentencias, a reducir más muertes maternas en las que estamos. Y eso sí nos ha enseñado como sociedad civil, nos ha enseñado a monitorear las situaciones, es decir, a visibilizar cifras, a contabilizar, a exigir estadísticas, como bien lo señalaba Ona, a visibilizar historias, quiénes son estas personas, ¿no? A incluirnos, como bien nos señalaba la señora Bandana, el tema, por ejemplo, del reporte de rendición de cuentas que va generando esta universalización de derechos. Y definitivamente a trabajar también con actores. También nos ha enseñado, y ahí vienen también los grandes desafíos, que cuando uno acompaña, es parte de un proceso estratégico. Ojo, estamos hablando de víctimas cuyas vidas han sido gravemente dañadas y que por lo tanto todo el tema de lo que significa la reparación, o sea, no tan solo la generación de políticas públicas, que es el sentido, digamos, de estas cuestiones, sino cómo se reparan estas víctimas. ¿Qué cosa significa devolverles todo aquello que se le ha quitado? Ojo, y no son procesos cortos, son procesos sumamente largos. Cuando conocimos a LC tenía 13 años. Cuando llegó la sentencia, LC tenía 19 años. Imagínense cuántos años pasaron para que ya una mujer en una situación inclusive de discapacidad prácticamente total enfrentaba la vida de adultez. Entonces, creo que sí es importante darnos cuenta en este sentido que también nos coloca como feministas, como activistas, la protección de la víctima, a que fortalecer su autonomía y en la toma de decisiones. Y también nos enseñó que lamentablemente el litigio no acaba con la sentencia. el incumplimiento, la resistencia, las barreras. Digamos, es un proceso de constante vigilancia. Tenemos que salir de este enfoque restrictivo en el cual se ha acostumbrado a ver a la mujer como personaje dudoso, como aquella que no tiene que tener la confianza y el favor de la ley. Entonces, hay todo un proceso para eliminar barreras. Sabemos que como resultado tenemos un protocolo de aborto terapéutico. No es el mejor, tiene serios problemas, pero es un avance. Y eso también nos coloca como movimiento a saber cómo vamos a negociar, qué cosa tenemos que admitir, cómo podemos avanzar, inclusive en un, digamos, piso lleno de dificultades. En fin, yo creo que el litigio estratégico nos ha ayudado a fortalecernos, a dialogar, a debatir, pero también a fortalecer competencias. Y con mucho orgullo puedo decir, tenemos una generación de abogadas, abogados muy sólidos, capaces de discutir y de defender con los mejores estándares de calidad. Y eso creo que es una ruta que no tiene retroceso. Muchas gracias.
Thank you so much. Thank you so much, Susanna, for your elaboration. And you just highlighting a very important point that litigation is not the end. We know that there's a big challenge of actually getting these decisions translating to actual changes in the lives of women and girls. And so the efforts and the push really still has to continue. We'll now turn to listen to Moses. Moses, my question is: we saw the trajectory of the Alain case. That the case, of course, transcended from a case of an intersectional discrimination and maternal health in a developing country to a case that Western Europe countries have had to look into to guarantee the right to maternal health of underserved and marginalized populations. Please share with us your reflections on the dynamics of intersectional discrimination and the role or the relevance of using strategic litigation to advance the rights in Eastern Africa, and also Sehud's experience in leveraging international human rights mechanisms to advance these rights. So welcome, Moses. 5 minutes to speak to us. And I remind everyone to please place your questions on the Q&A so that we can pick them up immediately after this. Welcome, Moses.
Great. Thanks a lot. I want to thank CRR for organizing such an important conversation, and also the panelists. I think for me, we've worked with CRR for a long time, and as the outgoing executive director for CEHAD, which has done litigations, I think one of the strong points that I take from this and the question that you're asking is the complexity of litigation, especially for sexual reproductive health and rights. I think something that is very striking is that sexual reproductive health and rights, and specifically maternal health, is both very contextual in litigation, but also highly connected globally. So it is very difficult for us to have a conversation on litigation that is only focused on a particular region and is not connected. And I think that we need to revisit the history in understanding why cases that we litigate find themselves beyond the national agendas towards the regional and global agendas, just like you've indicated. The historical events from an African point of view, for instance, have been very telling in terms of the litigations that we undertake. And we cannot have a conversation on just normative frameworks like human rights without contextualizing them within the historical events. It is these same historical events that seem to be reflecting in the domestic litigations and then later into the regional spaces that we see. In Africa, for instance, the judicial systems that we've had before colonization have continued to influence the outcomes of the cases that we do litigate. So you cannot just talk about a litigation in a modern society and let the traditional African society away from the way it was resolving its conflicts and the way it understood things. Quite a number of things are fascinating when one looks at them. When it comes to sexual reproductive health and rights, I think the patriarchal society cannot be dealt away with. This patriarchal society was reflected both pre-colonial and also during the colonial period, because when we actually saw colonialism come in the context, a set of laws was imported into our context. In the case of Uganda, we had the direct importation of British laws in Uganda, which, if you read them, they are also patriarchal in nature. And many of the challenges that they pose get back to the challenges we see that we are challenging in litigation in sexual reproductive health and rights. When you leave the judicial system and also focus on the health system, you actually see the same challenges that the pre-colonial period of Africa still persists and impacts on the litigations that we do today. Many of the things that we challenge, like, female genital mutilation, the discriminations that are based on one's sexual orientation, the questions on family planning and who makes the decisions in the home. Some of these were pre-colonial. And then what happened when colonialism came? They made it more formal through laws. They were unwritten, they were just practices that are unwritten. The colonial period actually rewrote them. And then they became part of the fantasies that we have continued with to date. And therefore, for me, when you see a litigation that is done at the domestic level to challenge some of these things, eventually picked up at a global level, it continues to be a challenge. But I also think that we need to look at the immediate period post colonization that we had. Some of the events that led to a lot of violence in some of the countries have continued to impact on sexual reproductive health and rights. And it's an international community's interest. In Uganda, we've had the northern part of Uganda that went through a war for 20 years. And what was very clear throughout the war in northern Uganda is violence against women, is sexual violence, is abuse, total abuse of the health system and total collapse of the health system. So some of these events, in a way, come back and feed into the litigations that we are doing. We cannot underrate the neoliberalism that we actually saw immediately after colonization in the 80s. What we've seen is that, the governments have disempowered themselves. The private sectors have been very strong. We have thrown sexual reproductive health and rights into the marketplace. And therefore, when you talk about presence of commodities, when you talk about, trade in labor, the way, women are now being slaves, like in Uganda, every single day, women that we see that are being taken to the Arab countries to act as modern slaves. These are things that we challenge in the litigation that we see. And this has been combined with the fact that our governments have actually deliberately failed to invest in health systems. They have failed to invest in the system that would advance things like maternal health. So when you look at all the litigation that we are doing, they are not just a concern of the national level, but they are a concern of the global contextual framework. And therefore, I think that the current conversations on how do we relook at our traditional societies and not only look at the negative things that advance sexual reproductive health and rights, but also advance an agenda on positivities, positive things that we saw on sexual reproductive health and rights in like the traditional African society being advanced more. Because if you look at the judiciary today, we still have very old gentlemen and women that are still rigid to traditional beliefs. And when they are making some of these decisions, we end up finding ourselves actually fighting things like, political doctrine, question doctrine, wasting a lot of time on process and procedure rather than the substance that we are handling. So the opportunities that are existing, I think, in the regional approaches are immense, and I think we need to tap into them. The East African community, for instance, now gives us a court which has more understanding on human rights. The African level, we have the African Union and the African courts that we have that can now settle things from a human rights point of view. You actually find that if you took a case at the African level and you challenged it and you challenge the government at the African level, you have a better understanding of the human rights framework than what we see at the national level. So the opportunities are there, but there are still challenges. The litigation is happening with lawyers that are trained as commercial lawyers. It is happening in a context where procedure is the order of the day. So there is a lot of delay in delivering of justice. And unless we address some of these things, it's going to be very difficult. And the international community cannot negate part of the bad history that they have actually created that we are trying to change. Thank you very much.
Thank you, Moses. And just to remind everyone again, please post your questions. I know people are also giving their emails as well to get the report. I think Emma said she'll put a link on the chat for the report itself, so you can be able to download it and access it. As we wait to do that, and as we wait to get more questions, I'm going to just pose a question to the panelists. And I think, Moses, you've left it as a very good point where you talked about the global context within which SRHR is practiced. You've touched a little on the question of, government, lingering effects of whether it's colonialism or past government engagement, patriarchy. I'd like just to ask the panelists to reflect on the fact that we are seeing a great backlash against international human rights law, particularly on matters that are related to gender and women's rights, and specifically, as some of the panelists have mentioned, against sexual reproductive health and rights. And I'd like us just to reflect and say, how can we ensure that the cases that we are discussing today remain still relevant in light of this pushback? And what role can the grassroots movement play to push against the anti-rights agenda? I'll just ask to go around the panel and have some reflections, 2 minutes reflections from each of the panelists. Starting with we can start off with Ms. Rana.
Okay. The intensifying backlash is very, very concerning also because the COVID pandemic has, been used to further regressive agendas as well. I think so that also needs to be focused on. But when you talked about how can we retaliate with this, I think a diverse movement building is required where you actually engage intensely with the youth and the grassroots movement, bringing in cases and voices from the grassroots. And particularly coming from human rights mechanism that even before I was in the CEDAW committee, in the context of Nepal, we have a very vibrant civil society, and we have used numerous jurisprudence, the recommendations to bring about legislative changes, to bring about formulate laws and policies. So I think at this stage, when in certain cases, in terms of human and financial resources, also the existing treaty bodies are being weakened, even with the COVID pandemic. So I think that we also need a stronger voice to strengthen the existing human rights mechanisms, as has already been validated by the cases that you have compiled about the kind of outreach it has, how it reaches out to regional commissions and also domestic spheres in liberalizing laws and policies. So I think a very vibrant movement, diverse movement building, engaging with the youth. Susanna talked about bright lawyers. So it has to be a diverse movement building and bringing in experiences, lived in experiences of grassroots women, their voices, and also sometimes innovative changes that they have made at the grassroots level could be a stronger movement. I think this is what we need to do. Thank you.
Thank you, Rana. Ona, if you could share with us your
yes. Well, I echo that sentiment and the importance of protecting institutions and building movement, and for that to happen. And I'm speaking here with my hat as somebody that works with a special rapporteur on the rights to peaceful assembly and of association and at the International Center for Not-for-Profit Law. We need to ensure that actual civil society and social movement have the space to do that, to engage, to collaborate, to speak up. And unfortunately, and this was even before the pandemic, we were witnessing a clear uptake in reprisal, threats, denials of visa, restrictions to funding of women's groups, advocating for sexual and reproductive rights, criminalization. I mean, the threats are real. And so my thought is that to garnish implementation, to be the new direction, should be strengthening social movements and grassroots, but that is only possible if we also keep our civic space open and vibrant. And so there has to be dialogue between those that are pushing for more expanded sexual reproductive rights, and those others that are pushing for more democratic space as well.
Thank you. Susana, your reflections on the question?
Sí, yo creo que es una pregunta clave y difícil de decirlo además en breve, pero yo creo que primero es importante recordar que este ha sido un proceso histórico y que además ha ido creciendo cada peldaño que se ha ido ganando. Por lo tanto, hay caminos que a veces podemos pensar que no están en peligro y que lo ganado ya está garantizado. Y lo que ocurre en América Latina, lo que ocurre en el mundo, podemos ver que eso no siempre ocurre de esta manera. Y esto significa seguir fortaleciendo aspectos, por ejemplo, que todavía nuestros países siguen adoleciendo, como el tema de las grandes brechas. Mientras que tengamos, digamos, grandes diferencias, discriminación, este intento de separación que ocurre en nuestra población, vamos a tener siempre precariedad y debilidad para defender los derechos. Por lo tanto, esto exige también una visión mucho más integral en la defensa de los derechos, en el tema de la defensa de las instituciones, como bien lo ha señalado Ona, pero también no perder de vista los sistemas democráticos. Esto solamente es algo que podemos ejercer en un contexto de democracia, así estas sean débiles, así estas no sean las que querramos, pero es lo que tenemos. Otro tema que me parece sumamente importante es no descuidarnos de la educación. Y la educación es un proceso en alta competitividad actualmente en América Latina. Es el mecanismo por el cual se pretende también controlar. Y allí creo que la independencia, el tema de las evidencias, que nuestros hijos e hijas reciban una educación de calidad, que la escuela pública sea un espacio de igualdad de derechos, resulta fundamental. Y finalmente quisiera señalar que es importante también visibilizar los costos que tiene la injusticia, la discriminación y la exclusión. Es sumamente costoso para el Estado y creo que hay que llevarlo con números, hay que explicar que cuesta mucho menos vivir en una sociedad igualitaria que en una sociedad de tanta desigualdad. Y finalmente, los grupos de oposición siempre van a existir. Ojo, no es que los querramos desaparecer. Y eso es bien importante para entender el tema de la pluralidad. Lo que queremos es que la población, la mayoría, sienta que tiene una opción y una elección en base a la información. Por lo tanto, más que, sé que tenemos que combatir a quienes piensan en contrario, pero no nos olvidemos del gran centro de nuestras poblaciones que todavía están en busca de información, de conocimiento y de este sentido común de los derechos humanos.
Thank you, Susanna. Moses, actually, there's a specific question that I think you can add a twist to the African context. There's a question about, I'm curious about what strategies African countries are taking to address the patriarchy encountered and whether younger activists are helpful in this process. Maybe Moses, you can take 1 or 2 minutes to answer that. I see you're almost coming up to the hour, because then I'd like to give Ali a chance to talk a little about the US pushback, which has also been asked in the chat. So Moses, welcome.
I think from where I sit, so many things are possible, but I will focus on the laws and policies that I work on. The mobilization that everyone has talked about has to be anchored within the framework of legal empowerment and social accountability, because I think we have seen a lot of laws, policies in place, but the community doesn't know how to use this. And we don't have communities that are holding the governments accountable. And in doing this, when we do legal empowerment, I think what is going to be critical is to think about a decolonized approach. How do we decolonize these old laws, old systems, old structures, like the judiciary? How do we decolonize the processes that we are subjected to in advancing rights? And then how do we legally empower the communities, including the youth mobilization, to actually be able to reclaim the public? You know, sexual reproductive health and rights, for instance, has to be reclaimed back as a public good. Unless we have social accountability that is mobilizing the advancement of sexual reproductive health and rights as a social good, it's going to be very difficult. And I think that the opportunity is currently there. The current pushback that we have on private sector, the current pushback that we have on disempowered states, and the current pushback that we have on over talking about just religion and other values that undermine things that are critical for advancing sexual reproductive health and rights, I think is critical. And the legal empowerment and social accountability is going to be key, but it has to be done within the frameworks of decolonization and challenging the privatization of a public good like sexual reproductive health and rights.
Thank you, Moses. I know I'm asking questions that can take a full day to have a conversation, and asking you to talk about it in 2 minutes. So I apologize for that. So just quickly, I know I've seen 2 questions on the US. I gave you a chance to talk on this first point, did I? Did I already? Honor, did we hear from you on the first question already? I don't want.
Yes,
Yes, we did.
Oh, thank you. I thought you were coming on the video. I'd like just to ask Ale to reflect. There are 2 questions on the chat about what we are doing about reproductive rights in the US, which are being suppressed by the state. And then, so Ali, we can take the 2 questions on the US, maybe 2-3 minutes. Again, it can be a discussion for a whole day, so just kind of quick highlights of what we are doing.
Absolutely. So one of the things we're doing is we've been pushing legislation at the federal level in Congress, and it's so far that process has advanced like significantly. No other law, comprehensive law on the recognition of reproductive rights as human rights had gone this far in Congress in the US. And we are taking an approach that I think we learned from the reproductive justice movement at large in the US, to not only address abortion in isolation, but to really understand that it is very important and critical to address reproductive and sexual rights as a whole. And this is what this law would be doing. And it would hopefully alleviate the Supreme Court in the United States to kind of have room to move the recognition of these rights back, if passed. But we're also working at the state level, and I have to say that there's a robust movement in the US at the grassroots level that works on reproductive justice, and there's been important achievements in some states. And I think that we have to learn from the lessons, the successful lessons of those states, and that's what we're doing, trying to replicate that across the country. So the New York, for example, New York State has been a great success in recognition and constitutionalization of reproductive health and rights as a whole, not just abortion. And so there's also been, I think, an awakening as this backlash has happened in the US.
Thank you, Ali. I know we still have open questions in the chat. I'm also aware that we are coming up to the top of the hour. We only have 4 minutes. Maybe, Ali, what we can do is collect some of these questions and put together some answers as part of the report. I don't know how there are many questions, and they're really important. And I'm sure they would also have really benefited from the perspective of the panelists. I can see also questions about possibility of following up more directly on some of the issues with the panelists. So maybe as a way of just ensuring that we give the final words to our great presenters, maybe spend the last minute giving each of them a minute to just give us some closing remarks, some reflections, and if you've got resources you might want to put on the chat that groups can refer to, and then we'll see how to consolidate some of these results, some of the questions, and share to the team, or some of the discussions, like, for example, around impact, we can continue some of those engagements in another webinar, because we actually do have ways that we try to get the impact even a couple of years down the line. So let me take this opportunity to invite, this time maybe I start backward. I ask Moses to take 1 minute and just give us your closing remarks, your closing reflections, and really apologizing for not answering all the questions. They're good, but we are coming up to time. So Moses.
Thank you so much. I think for me, in the closing remarks, litigation continues to be a very important tool, but I think we should not just look at it as a tool for winning cases. It's rather a tool that we use to strike a balance where there is an imbalance. It's a tool that we should use to start useful conversations. And any process of litigation has to be followed by robust advocacy. So I think civil society activism and community mobilization is going to be important, be it litigation at the national level, regional or global level. So for me, I will think that we continue the efforts that we have, but we need to accompany the litigation with the necessary advocacy. Thank you very much.
Thank you, Moses. I will call upon Susanna to give us your reflections and closing remarks.
Sí, bueno, primero, gracias por la oportunidad de estar acá. Creo que soy la única no abogada y eso hace también un poco más difícil, digamos, apuntalar a las preguntas. Pero algo que sí me quedo con mucha claridad es esta importancia de generalizar este proceso de universalización, por llamarlo de algún modo. Cómo lo que se hace en un país puede tener un enorme impacto en otro. Y sí me hace pensar que efectivamente en estos tiempos de cambio, de mayor conexión, pero también de desastres mucho más globales, como que nos ha pasado, por ejemplo, con el COVID, nos coloca también como mundo en un mundo con mayores posibilidades de conectarse y de generar corrientes que probablemente hubiesen sido improbables para nuestras realidades locales, para nuestros mundos pequeños o para nuestros aislamientos como organizaciones. Entonces, sí estamos frente a un gran desafío de globalización, de nuevos temas, pero también de aprendizajes y también de necesitar que este movimiento de pro derechos tenga a su vez, digamos, corrientes y apoyos conceptuales como el que nos está entregando el Centro de Derechos Reproductivos en entender estas conexiones para justamente hacer más activa esta posibilidad de hablar de un movimiento global mucho más fuerte, mucho más integrado para la defensa de los derechos sexuales y reproductivos. Y gracias por la oportunidad de estar acá.
Thank you, Susanna, and thank you for the partnership. We really appreciate the work that we continue to work with you on the ground. Ona, may I give you a minute for your conclusion?
Sure. So I think of this as, obviously, we're going to be engaging in strategic litigation for the next 20 years. So one thing that we saw in the last decade was the conjunction of how social movements work with cases, you know, and even when those cases were threatening previous gains. So in Poland, incredible mobilizations, you know, on the street trying to send a message to the courts that those gains were important. So protest movements on the grounds. And I would like to see those cases reverberating around the world and also being accompanied by women's marches and protest movements that are possible everywhere around the world too.
Thank you, Anna. And now, last but not least, Ms. Bandana, and then I'll give Ali the last word to tell us the next point. So Ms. Bandana, please, your reflections and conclusions.
I actually, this is unexpected. I actually don't have anything to add from what has already been shared about being vigilant, having a diverse movement building, you know, engaging with the diverse actors. And as I said, the strengthening the existing human rights bodies, particularly CEDAW in terms of where discrimination against women is concerned. We need to do that as well. That's it. And thank you for this opportunity. Thank you.
Thank you so much, Ms. Rana. Ali, I know we are out of time, but just maybe a minute or two. There was the question about what next. How do we capture impact? Do you have any words to our participants on how you're going next?
So how we are going to be, like, this knowledge has allowed us to understand that there are all these repercussions that we didn't even were planning for. But now that we have more awareness of how this interconnectedness is happening, we are hoping to leverage how we are working with different partners and how we can make this knowledge more available so people around the world can just take on these tools and use them for their own purposes, and they can be used in cases that are not strictly on sexual and reproductive rights, because these standards are just good in general for the fight on social rights and some of the things that Moses and Susanna were talking about. So we just hope to really keep making knowledge available and providing people with tools so we can all keep benefiting from each other and the interconnectedness of this wonderful world that also allows us to work in unsuspected ways with people around the world.
Thank you so much, Ali. And I will take this opportunity just to also express my great gratitude to our wonderful panelists, also to Ali and your team for putting together this report, to our participants for such lively conversations. We've put some answers to some of the questions online. We are also going to avail this recording of the webinar on our website, a CRR website. And if you look on the chat, you'll also get the report, the full report that we are talking about today. So continue engaging with us on our website, send us questions. But just to mention that, as we've all said, it's a movement and none of us can do it alone. So looking forward to continuing the conversation, continuing pushing forward, and wishing everyone a fantastic day, fantastic evening, or fantastic morning, wherever you are, and see you in the next webinar. Thank you so much.
Thank you, everybody.